Your Honor, if I may begin. Your Honor, if I may begin.
Yeah, please go ahead.
Your Honors, may it please this court. My name is Ryan Low, and together with my co-counsel, Mr. Chester Ong, we appear on behalf of the petitioners, the Fairland companies. We will be speaking for 14 minutes each, and we reserve 2 minutes for rebuttal. I'll be presenting to this court on the first issue concerning the enforcement of the Utopian Court's order for consolidation, and thereafter, Mr. Ong will be addressing this court on the second issue, on the release of third-party claims. Today, we ask this court to enforce the Utopian Court's order of consolidation. If successful, the Fairland companies will be substantively consolidated, their assets and liabilities will be pooled, and any intercompany claims will be wiped out. The issue before this court is whether the enforcement of the Utopian consolidation order is contrary to New Zealand's public policy. We submit that it does not. It is not. There are two avenues for the public policy exception to be established. The first, where there is evidence of procedural unfairness. The second, where there is violation of a fundamental statutory or constitutional right. These two avenues were taken from the 2011 Virginia District Court decision of Ray Kimonda. Now, before I go into my submissions proper, I would like to emphasize before this court that the threshold for the public policy exception is a high one, and this is because the drafters of the model law intended for it to deal only with principles or matters of fundamental public policy. And this can be seen in the Singapore International Commercial Court's 2024 judgment of Garuda, Indonesia. And in
But excuse me, Counselor, but apparently the case refers to the model law as adopted in the state of New York, but Singapore has adopted the model law differently, actually, because we have included the word manifestly. So why are you referring to the Singapore case?
well, for two reasons. Because the case of Garuda International used the model law drafter's intent based on section Article 8 of the model law, which is also incorporated in the New York equivalent statute here in New Zealand. And for the second reason, because the New York statute also has the word manifestly, and the word manifestly, according to the US House report on the Code of Bankruptcy, is specifically included to convey or reinforce the high threshold that was intended by the model law.
Yeah, sorry, Counselor, but then are you saying that Singapore has adopted the model law, including the manifestly or excluding the manifestly?
We are saying that Singapore um, adopts the model law with the inclusion of the word manifestly, but in the
Actually, it's
judgment,
not. It's not included.
apologies, in the judgment, it was based on the model law's drafter's intent. But here in New Zealand, we submit that regardless of the intention, we can either use the drafter's intention or the word manifestly as evidence that the public policy exception requires a high threshold.
Yeah, no, I totally understand. But then in that case, I'm not sure that citing a Singapore law is relevant because in Singapore, the legislature decided to omit the word manifestly, even though, as you mentioned, that case of Garuda actually speaks about the intention of the drafters of the model law. So please continue. Yeah.
Certainly, Your Honor. Now, onto my first point of submission, we submit that there is no procedural unfairness in the present case because the creditors were not shut out from the restructuring process. The relevant inquiry here is whether the creditors were accorded an opportunity to participate in the relevant insolvency proceedings and to have their views heard, as held in the 2011 Oklahoma Bankruptcy Court decision of In Re Civic. Now, the respondent will point this court's attention to paragraph 22 of the facts, which suggests that the creditors were not consulted ahead of the restructuring or the reorganization of the Fairland companies and the consolidation, and that the board of directors had simply approved the plan and went ahead with it. But I would like to point this court to three salient facts. The first is at paragraph 23, where Dexter Aviation filed an interim application in Utopia, and Dreamland Local sought an injunction against the consolidation on grounds of breach of fiduciary duty. The next will be 2 pages later at page 8 on paragraph 24H, which subjects the restructuring plan to 75% approval of the creditors and stakeholders. And finally, at paragraph 31, we see that the creditors enjoy a right of appeal and have exercised this right of appeal to the Utopian Supreme Court. And this right of appeal is significant because it shows that the respondents had no objections to the procedural conduct of the Utopian bankruptcy court proceedings. Their grievance in Utopia concerns the merits of the substantive consolidation. And we say that on the back of these facts, there can be no procedural unfairness. And in the 2014 New York District Court decision of Reed Energia, the court reached the same conclusion on the basis that the creditors in that case enjoyed the same rights that the creditors of the Fairland groups of company enjoyed here in Utopia, and that there was no procedural unfairness in that case. Now, moving on to my second submission, we submit that there is no violation of a constitutional or fundamental statutory right in New Zealand. In fact, the courts in New Zealand here have the power to order a substantive consolidation in their very own domestic restructuring proceedings. And this power is provided for under Section 1123 of the New Zealand Insolvency Statute and was judicially recognized in the 1988 Second Circuit decision of In Re Orgi Restivo. Now, the respondent may argue that it is the circumstances which the substantive consolidation is sought which engages the public policy exception. And this is because the substantive consolidation would result in a breach of fiduciary duties because it is not in the best interest of the company. We say that there are three reasons why the respondent is wrong on this front. The first is that the respondent's arguments on breach of fiduciary duty are res judicata. What they are doing is attempting to relitigate the merits despite a final and binding utopian judgment. And this is part of their wider strategy of forum shopping to stymie the restructuring process. We can see this at paragraph 36 and 37, where they filed an application against the consolidation order on the same grounds of breach of fiduciary duty here in New Zealand. And then at paragraph 37, the creditors also filed a separate Chapter 11 petition in the New Zealand court, notwithstanding that they had participated in restructuring proceedings in Utopia, which is the COMI of the Fairland companies. So these facts put together.
And Councillor, is a company required to file for bankruptcy to initiate insolvency proceedings in the place of the debtor's COMI?
No, but the fact is that they have raised the same arguments in the COMI. They have participated in those proceedings, and now they are attempting to raise the same arguments here in the recognizing court. Not only that, they have also appealed the merits of the decision in the COMI. So we say all these facts put together show that they're attempting to relitigate the merits and have a second bite of the cherry after they had failed on the grounds of breach of fiduciary duty in Utopia. And we say that this is not allowed. This is a waste of judicial resources, as noted in the 2009 Southern District of New York decision of Re-Atlas Shipping, and therefore cannot be used to establish the public policy exception.
Yeah, but Councillor, you mentioned that that our local laws allow substantive consolidation, and that's why it shouldn't violate our local public policies in New Zealand. But the truth is that the use of substantive consolidation is very limited to very exceptional circumstances. So do you think that these circumstances can be observed in the present case?
Yes, Your Honor. Well, this is because the creditor's best case is that the Dreamland local would be prejudiced because the assets of the more asset-rich fair land ground operations would be diverted to meet the claims of other creditors. Now, the key here is whether this constitutes a substantive or substantial deviation from New Zealand insolvency law and their priority scheme. And we say this is insufficient, or the present case is insufficient to establish the public policy exception on the facts. And this is because what the respondent points, or the prejudice that the respondent alleges will arise to Dreamland Local, is only a feature and not a bug of substantive consolidation. There is still adherence to the priority scheme in New Zealand, because that is what happens in the New Zealand context when substantive consolidation is ordered. And in any event, such minor differences, that is, differences in creditors' entitlements within the same class, cannot engage the public policy exception, as we see in the English decision of Ray Agrocor, as well as the US decision or the Florida decision of British American Isles of Venice. So even if substantive consolidation is a very drastic remedy here in New Zealand, we can see that there is a degree of integration and intermingling, the existence of intercompany loans between the fair land entities. And we say this shows that even if domestic law is applied, there is still some grounds on which a substantive consolidation can be ordered.
Okay, and you mentioned also, Councillor, that another reason for ordering substantive consolidation is that it can make the creditors better off, right?
Yes.
Have you used any specific indicators, comparisons in order to prove your point?
Well, Your Honor, we do not have any specific numbers available with us here. We say that the substantive consolidation is beneficial because it is a necessary first step to the reorganization plan. This was a point that was noted by the Utopian Court at paragraph 24A, that the creditors will be consolidated into a single proceeding solely for the purposes of reorganization. And second, we say that the pooling of the assets and liabilities allow the less profitable fair land entities, that is, Fairland Aviation and Fairland Locomotives, to be saved, and ensures the symbiotic relationship between all three companies who rely on one another for operational and logistical support to continue, and ensures the survival of a group as a whole, which maintains the going concern value of the company throughout the restructuring process.
Yeah,
No.
but Councillor, as you know, in our country, we respect Salomon, and that's why we truly respect like the different legal entities, the different legal personality that each legal entity has. So that's why substantive consolidation should only be used in very exceptional remedies. So you think that those exceptional circumstances are observed in this case?
Certainly, Your Honor. But even if the threshold in Utopia is slightly or is lower than what it is in New Zealand, the principle of comity enshrined in Chapter 15 and the aim of harmonizing between the different jurisdictions, between harmonizing the approach taken in different insolvency proceedings, in different foreign insolvency courts, demands that the decisions of the Utopian court be respected. As I emphasized earlier, the threshold for the public policy exception is a high one. And what the respondent bears the burden of showing is that there is a substantial deviation, not just mere deviations from the requirements of substantive consolidation as required under the Chapter 15. Unless I may be of further assistance to this court.
Nothing. Thank you.
This concludes my submissions.
Your Honor, if I may.
Please continue. Yeah. Go ahead, please.
Your Honor, as earlier introduced, I am Chester Ong, and I continue the case for the petitioners. With the remaining time, I will address this court on the second issue on whether it is empowered to order the third-party releases as part of the reorganization plan. As a preliminary note, we note from we note that the releases are part of the plan and can be found in paragraph 21E of the facts. And as stated by my senior counsel, the Utopian Bankruptcy Court has already approved the plan on 1st January 2024, as noted in paragraphs 24H and paragraph 25, after it was satisfied that it had received the requisite creditor approval. Hence, it is our submission that the releases are consensual third-party releases. And so this court's task is to determine whether it is empowered to grant the releases here in New Zealand. To that end, we make two submissions. First, that this court is empowered under Section 1521 of the New Zealand Insolvency Statute, and second, in the alternative, that it is empowered to do so under Section 1507 of the same statute. Turning to my first submission, upon recognition, this court can grant the releases through Section 1521 as part of an appropriate relief. Per the 2012 Fifth Circuit case of Re Vitro, the wording of the statute is deliberately broad in order to allow the courts to grant relief even if they may not be specifically domestically available under Title 11 bankruptcy. This suggests here that in New Zealand, when Section 1521 is applied, right, this court applies the law of the foreign court, in this case, the Utopian Bankruptcy Court's decision, to determine whether it can grant the releases. And so, at first blush, there is no obstacle for this court to grant the releases, given that Utopia has already done so. However, this is not to say that this court must always defer to the Utopian Bankruptcy Court's decision. As noted by former Southern District of New York Bankruptcy Court Judge Alan Gropper, there are breaks to comity, such that domestic courts can apply foreign decisions, have the discretion to apply foreign decisions. As the respondent points out, the break to 1521 in this case is 1522A, where 1522A only allows remedies if the interests of the creditors and debtors are sufficiently protected. Per the 2006 case of Tricontinental and the 2019 case of Reania, the court here determines whether there is sufficient protection by conducting a balancing test to determine whether the financial interests of the creditors and debtors are sufficiently protected. So firstly, on the debtors, the releases protect them by allowing the Fairland Brothers and Rover Capital to focus on reorganization plans. Furthermore, Rover Capital specifically is protected against ricochet claims, where a claim against them would harm their ability to contribute to the reorganization plan. As we can see from paragraph 21B, Rover Capital has promised to inject $15 million in debtor-in-possession financing as part of the reorganization efforts. As litigation against them may harm their ability to provide such financing, we submit that the releases are in the interest of the debtor companies.
And
Second,
Councillor, one question. So what do the creditors think about the releases? So do you have any kind of qualified majority from the creditors who are supporting the releases?
Your Honor, the answer to that can be found in paragraph 24H. So from the third last line, we see that the Utopian Bankruptcy Court, before it can approve the reorganization plan, requires approval from at least 75% of the creditors and stakeholders. As we can see at paragraph 25, the Utopian Bankruptcy Court has indeed approved the reorganization plan. So we see that the requisite creditor majority from the Utopian Bankruptcy Court has been met. Now we note here,
but Councillor, even you have a qualified majority of the creditors. For example, recently in the United States, the U.S. Supreme Court says that certain non-third-party releases cannot be included in the plan unless you have like full consent from the creditor. So in other words, if you don't have a third-party release that is fully supported by all the creditors, that can be controversial. Is that the case here?
Well, Your Honor, 2 points. Firstly, as described by my senior counsel, the crux of whether or not this court should recognize the releases specifically is whether or not the Utopian Bankruptcy Court's own threshold has been satisfied. Given that the Utopian Bankruptcy Court has already approved the plan, the principle of comity suggests that here in New Zealand, So long as the Utopian Bankruptcy Court was satisfied, this court is empowered to grant the releases here. Secondly, we note your concern that perhaps there must be unanimous approval. However, and this is a point that a respondent has noted as well. However, it is simply practically difficult in order to get a resolution to obtain such unanimous approval. And so we further submit that the ordinary threshold that the Utopian Bankruptcy Court is set is preferable to such a high threshold in a matter of practicalities. And so, given that the interests of the creditors and the debtors have been considered, and that the creditors have even approved the plan, nothing stops the application of 1521 relief, and that 1522 does not bar the relief under 1521. Turning to my second submission, 1507 in the alternative grants this court the same powers to order the releases. Returning back to re vitro, 1507 is described as a catch-all provision, where so long as where remedies, even if unavailable under 1521, can still be granted under 1507. 1507A's requirement to trigger relief can be found in a plain reading of the statute, where 1507 grants remedies under this title or other provisions of Title 11. So our submission here is that 1507 can be applied so long as the New Zealand court can point to a domestic remedy that is equivalent to the foreign remedy being sought here. Here, we submit that the relevant Title 11 provision is Section 1123(b)(6), which domestically allows the New Zealand court to include any additional provisions as part of a domestic bankruptcy plan, which includes third-party releases. We pause here to acknowledge the respondent's reliance on the 2024 United States Supreme Court case in Purdue Pharma to suggest that the releases cannot be granted at all, as Purdue Pharma stands for the position that third-party releases can never be granted. However, we note that the ruling in Harrington constrains itself.
Excuse me, Councillor, it says that third-party releases can never be granted or only non-consensual third-party releases?
Precisely, Your Honor. The ruling in Purdue Pharma has constrained itself to non-consensual third-party releases. Hence, as earlier described, the consensus here are consensual. The releases here are consensual, and thus Purdue Pharma should not apply. In any event, even if the releases were labeled non-consensual, we submit that Purdue Pharma still does not prevent the granting of relief with respect to assets of a foreign company in the context of Chapter 15 proceedings. As a preliminary point, we note that the case of Purdue Pharma was exclusively concerned with Chapter 11 domestic proceedings, and so its ruling should not easily transplant over into foreign proceedings. We submit also that the true ruling of Purdue Pharma can be distilled from page 10 of the judgment onwards. There, the court arrived at its holding that non-consensual third-party releases can never be granted by relying on the canon of statutory interpretation of ex judem generis, where they read the statute and its surrounding provisions to decide whether or not Chapter 11 grants courts powers to order non-consensual third-party releases. And there, it submitted that the court could not find within 1123(b)(6) or its surrounding provisions any sort of express power. However, we submit that this doctrine provides the opposite outcome when applied to Chapter 15 proceedings, as Chapter 15 provides the surrounding context that Purdue Pharma was missing in the Chapter 11 context. We refer to Section 1501, which provides that the legislative objective of Chapter 15 generally is to encourage comity across jurisdictions. Hence, our submission is that 1123(b)(6), when is referenced in an application for relief under 1507, there is sufficient legislative justification to allow non-consensual third-party releases, even in Chapter 15 proceedings. And so, we submit that the present facts do not conflict with any of the rulings in Purdue Pharma. With the power to grant the releases, consensual or otherwise, under 1507, we turn to 1507's break on comity, which is the just treatment of creditors under 1507(b)(1). Per the 2018 case of Reavanti Communications, Just treatment is satisfied so long as the foreign proceeding provided creditors with due process. Here, the respondent suggests that nothing on the facts shows that factors of due process, such as the opportunity to be heard, can be found on the facts. However, we will disagree on this. They raise paragraphs such as paragraph 22, where the Grand Felon and Gem Felon consulted the board of directors and came up with the reorganization plan without necessarily consulting the creditors. However, we submit that the creditors were consulted, and they were consulted starting from paragraph 24G and 24H. Turning to paragraph 24G, we see that the Utopian Bankruptcy Court directed that the insolvency administrator is to assemble a common committee of creditors and stakeholders to address and reduce conflicts in decision-making. Next, at paragraph 24H, we see that any approval must be subject to 75% of creditor and stakeholder approval. And 25, we see that eventually the Utopian Bankruptcy Court approved the reorganization plan. So we submit that is at this juncture between paragraphs 24G and H and paragraph 25 that the creditors were given all the facets of due process. They were given full disclosure on the context of the plan and the contents of the plan, and they had sufficient opportunity to be heard and discuss any potential conflicts. And so the petitioners bring to this court a final and enforceable judgment that has fulfilled all of the requisites of due process. And so we have discharged our burden of proof to show that the creditors have received the elements of due process. We are referring to the case of re-agricor. Should the respondents still have any contention about whether or not procedural unfairness was made out, the burden of proof would thus shift to them. And here, additionally, we see that the creditors have raised several challenges to the Utopian Bankruptcy Court's decision. However, as noted by my senior counsel, all of them have been on the merits, which further suggests that they will accept the ruling of the Utopian Bankruptcy Court. First, they accept the procedural fairness of the Utopian Bankruptcy Court, choosing instead to appeal on its merits to the Utopian Supreme Court, which is further evidence to suggest that there has been no procedural unfairness. And thus, 1507b1 is also not an obstacle to relief under 1507. And so, Your Honours, in conclusion, the creditors are attempting to slam the brakes on a bona fide restructuring program that has already obtained the requisite approvals from creditors. Their day in the sun to air their grievances has come and gone, save their pending appeal, and accordingly, this court should recognize the decision and pass the necessary orders, including the releases, following the principle of comity. Now, Your Honours, unless I may be of further assistance.
Dear Councillor, one final question. So, do you want me to recognize, a decision, even if we haven't adopted the model law on recognition and enforcement of insolvency-related judgments?
Sorry, Your Honour, could you repeat the question?
Yes. So, we need to distinguish recognition of proceedings from recognition of insolvency-related judgments. So do you want me to recognize this as an insolvency-related judgment?
Yes, Your Honour.
Yes, but do you think that the fact that we haven't adopted the UNCITRAL model law on recognition and enforcement of insolvency-related judgments may prevent me from doing so?
There will be no obstacle to this, as Section 1521 grants this court the power to order the various forms of relief upon recognition.
Okay, thank you for the clarification.
Unless I may be of further assistance.
Nothing. Thank you so much, Councillor. Yeah.
This concludes my submissions. Thank you.
Your Honours, if I may begin?
Please, yeah.
Your Honour, may it please this court, my name is Stephanie Hing, and together with my co-counsel, Ms. Shermane, we act on behalf of the respondents, Dreamland Locomotors, Dexter Aviation, and Bridgerton. We will each be speaking for 15 minutes, I will address the first issue on the recognition and enforcement of the consolidation order, and my co-counsel will address the second issue on the release of third-party claims. In 2020, owing to the COVID-19 pandemic, personal guarantees were extended to the creditors after Phelan Aviation and Phelan Locomotors defaulted on payment. Despite this, the group sought and obtained approval for a consolidation order in the Utopian Bankruptcy Court. While we do not contest the procedural requirements for recognizing this order, this court should not enforce the consolidation order under the public policy exception. And this is for two reasons. First, that the creditors were not accorded procedural fairness in the events leading up to the Utopian proceedings. And second, that the directors have acted in breach of their fiduciary duties in obtaining this consolidation order. Now, to note preliminarily, the Senior Counsel for Petitioner has noted the concerns about relitigating the merits of this case. However, that the public policy exception was enacted so that each country could safeguard their local interests. And so the principle of comity, as stated in the case of Toft in 2011, means that comity is never a categorical deference to foreign proceedings, and this court should consider each case based on the public policy exception. And this court should do so on the policies of procedural fairness and fiduciary duties. Now, in the case of procedural unfairness, the key concern here is that the creditors were not consulted on the consolidation, despite this being a key term in the plan. And as stated in the case of Garuda Indonesia in 2024, it is paramount that the creditors be notified of and actively engaged in the steps that are being considered. This can include whether or not to proceed with a corporate restructuring of the company's debts or its liquidation. And here, the creditors should have been consulted on whether or not the companies should proceed for a substantive consolidation. And as stated at paragraph 22, the consolidation was approved by the management of the board of directors of the Fairland companies without any suggestion that the creditors were consulted. And I note that the Senior Counsel for Petitioner has made some reference to claims in paragraph 23. However, it first should be noted that these are litigation claims and not claims in order to contest the merits of the consolidation order. Instead, this would allow for any awarding of damages rather than to prevent the consolidation order from taking its effect. And further, these litigation claims are not a sign of foreign shopping, since the creditors were simply trying to protect their rights and to remedy any procedural unfairness.
Counselor, one quick question. So you mentioned foreign shopping in kind of pejorative terms. So is foreign shopping bad?
We would say that foreign shopping is not bad when we look at the motives behind who applies for such applications, where here the creditors were simply trying to make these applications in order to have their opinions and concerns heard rather than to choose a forum that would be the most beneficial for them in order to avoid any adverse consequences. It was simply a way for them to address the procedural unfairness that was accorded to them.
Okay, thank you.
And it must be further noted that the enforcement of the consolidation order would be procedurally unfair, as it also sidesteps the appeal in the Utopian Supreme Court, inhibiting the creditor's right to appeal, as there could be concerns that it could produce conflicting judgments on the consolidation's validity, defeating the aim of achieving an orderly and equitable distribution of assets. Now, the concern with enforcing the consolidation order prematurely before the appeal has concluded is that the creditors would suffer prejudice. Not just the creditors, but the company would also suffer prejudice that would be difficult to remedy if the appeal was successful, and there would have to be a reverse of the enforcement of the consolidation order here. Which is why we would say that it is premature to enforce the consolidation order when there is a pending appeal. Now, the prejudice that the creditors and companies could be suffered is the effects of the substantive consolidation as well as the effects of the plan. Which brings me to my second point, that the directors have acted in breach of their fiduciary duties in obtaining this consolidation order. Now, first, it must be noted that fiduciary duties can be seen as a matter of public policy, and that was affirmed in the case of Girth and Loft, where it explicitly described fiduciary duties as a form of public policy to ensure that directors strictly adhere to their duties, since fiduciary duties form the bedrock of corporate law. And we note that statutory protection can be viewed as public policies by this court, so long as it can be related to the fundamental policies behind it. And this was seen in the case of Cumonda, where they looked at the rights of licensees under the Intellectual Property Bankruptcy Protection Act, where it related to the public policy of promoting technological innovation. And similarly, this was also seen in the case of Toft, where they looked at various statutory protection of privacy rights. So we would say that this court can consider fiduciary duties as a form of public policy.
Yeah, but Councillor, one question. The directors owe fiduciary duties to the creditors or to the company?
We would say that they own the duties primarily to the companies, but it's extended to the creditors after the directors became aware that the company was within the zone of insolvency, and that is when they began to owe fiduciary duties to the creditors. And this was seen in the case of Carreri and Job.com in 2004. Now,
Yeah, but as you know, some jurisdictions don't recognize that duty shift. For example, the United States is an example of a jurisdiction where the duties don't change even in the zone of insolvency. Do you think that this type of foreign cases should be relevant for this case?
Since this is related to the public policy exception, we would say that this court its primary focus is to focus on the laws of this state rather than to the foreign cases, but that the foreign cases can act as guidance. And we would say that even if this court is not to accept fiduciary duties being owed to the creditors, there are sufficient facts to suggest that the duties owed to the companies have been breached here by obtaining this order for consolidation. Now, Your Honour queried the Senior Counsel for Petitioner that the substantive consolidation is only awarded in the most limited of circumstances due to the importance of separate legal personality. And this was affirmed in the case of Owens Corning in 2007, stated that entity separateness must be respected as and I quote, a fundamental ground rule of limited liability. Thus, this court should consider that substantive consolidation is the most extreme measure that can be awarded when there are other less extreme measures that can be considered. And Your Honour also queried on if there are any points of comparison to suggest that the consolidation order would lead to a better scenario. However, we would say that the Senior Counsel for Petitioner has failed to note that there are enough facts to suggest that a situation without a consolidation order would be more beneficial for the companies. Now, this can be seen particularly in the case for Go, where the consolidation order would lead to prejudice suffered by both the companies and creditors, where with the consolidation order, it would mean that the Go's assets and liabilities would be combined with all the other entities, which means that its profits and assets can be stripped from it in order to be redirected to pay off the debts of Fairland Aviation and Fairland Local. Yet Fairland Go has its own debt obligations to pay to Dreamland. Thus, without the consolidation order, Dreamland is more likely to claim back its full principal, debt, and interest within the stipulated deadlines, since Fairland Go is profitable. Now, this is not the only fact that suggests that the substantive consolidation will not lead to a better scenario, where the details of the plan itself suggest that it may not be successful. Now, it states that with the consolidation order, the 15 million debtor in possession financing is to be spread across the entity's combined steps. Yet the principal debt that is owed to Dexter already amounts to at least 1.2 million, as stated at paragraph 16 in relation to the hire lease agreements. And further, supply arrangements for Bridgerton for a duration of 5 years likely amounts to an estimated 20 million, and this can be calculated from the losses of 12 million that Bridgerton suffered due to rescinded contracts from a 3-year period of 2020 to 2022. And that was just for rescinded contracts. So together, these debts far exceed the 15 million that is to be provided. Furthermore, it suggests that Rover filed Chapter 11 proceedings as it is in a liquidity crunch, as stated at paragraph 35, suggesting that they are having some capitalization, suggesting that they are insolvent and thus unlikely. It raises questions on their ability to provide this debtor in possession financing. And this situation can be compared to a situation without the consolidation order, where Feather Go is able to pay off its debts. And secondly, that at paragraph 37, it states that Dexter Aviation has proposed an independent debtor in possession financing option to Fairland Aviation with the option to convert this financing to equity. So with this option, it is more likely to claim back its 8 million due to Fairland Aviation's breach of contract, and there is more likelihood that this amount can be provided to Fairland Aviation since Rover, in comparison, is in a liquidity crunch. Now, case law has substantially shown that substantive consolidation is only warranted in the most limited of circumstances, and this is usually where there is insufficient record keeping of the interrelationships between each group. And this can be seen in the case of Chemical Bank New York Trust Company, where it stated that substantive consolidation is only justified when the interrelationships of the groups are so hopelessly obscured and that the time and expense necessary to unscramble them are so substantial that they threaten the realization of any net assets for all the creditors. But we don't see that here where we can specifically identify the amount of the monetary value of the transactions between each company, each entity in this group, such that it is possible for them to be consolidated independently and separately. And furthermore, the other less extreme measures could have been considered by the creditors and by the debtors, by the directors of the company. For example, in the case of Republic Airways Holding, the court considered a measure of partial consolidation, where the creditors who agreed to the consolidation were treated as if the entities were combined, and the one creditor who objected to the consolidation was treated separately as if the entity was independent. There are also other measures that the creditors could have considered by, for example, procedural consolidation instead, where there is a consolidation of the proceedings in order to allow one court to consider all the claims in one court so as to allow for more procedural efficiency, but the entities are still considered separate and independent. And we would say that is why the procedural unfairness and the fiduciary duty claims are interlinked, where because of this lack of consultation with the creditors, these measures could not have been considered, and thus leading to the most extreme measure that prejudices both the companies as well as the creditors. So in conclusion, we would say that this court should not enforce the consolidation order, as the creditors were not accorded procedural fairness in the events leading up to the utopian proceedings, and second, that the directors have acted in breach of their fiduciary duties in obtaining this consolidation order. Now, unless Your Honor has further questions,
no further question. Thank you.
This concludes my submissions. Thank you.
Your Honor, if I may begin.
Please.
Your Honor, may it please this court, I'm Shermane and I'll be continuing the case for the respondent. I'll be speaking for 15 minutes. Following the consolidation plan as laid out at paragraph 21 of the facts, such third-party releases of the debtors grant Fairland, Gem Fairland, and Rover Capital cannot be granted by the court today. And I'll be demonstrating why the petitioner's case will fail on 3 main points. First, that the third-party releases here have not been consented to. And second, the third-party releases will not be provided for under Section 1521 and Section 1507 of the New Zealand Bankruptcy Code. And third, accordingly, the holding in the 2024 US Supreme Court decision of Purdue Pharma will still be applicable and relevant today. First, contrary to what junior counsel for the petitioner argued earlier that such third-party releases are consensual, we disagree. And I also earlier picked up on Your Honour's question regarding whether the 75% approval has been obtained. And here, it's our submission that no requisite approval of the 75% has been given for these third-party release provisions. And it's our submission here that the main concern is regarding what the make-up of this 75% entails. Your Honour, if I may refer you to paragraph 24H of the facts, at the second last line, it can be seen that the 75% approval consists of not only creditors, but it also includes stakeholders. And with an inclusion of stakeholders in the voting process, this is an anomaly, as case law has shown that when seeking approval for reconsolidation plans, only the creditors are to be taken into account. And Your Honour, I would like to highlight the 2012 US Fifth Circuit case of In Re Vitro. And there, the court held that the reconsolidation plan has not been consented to, although the reconsolidation plan got over 74% approval. And this is because within this 74% approval, over 50% who voted in favor of the plan were not only creditors, but were considered to be insiders, which were Vitro subsidiaries. Similarly, in our case here, the 75% approval cannot be said to have been satisfied because within this 75%, it consists of also stakeholders, and nothing on the facts also indicates clearly how the voting process was being done. Hence, such an inclusion of stakeholders within this 75% could have caused a dilution of the votes. With such factual uncertainty as to who constitutes stakeholders too, this court today should not rule that 75% approval has been obtained regarding the third-party release provisions. Furthermore, it must also be noted that this could include some creditors who are not part of the third-party releases or who are not bounded by such third-party release provisions. Therefore, this 75% approval cannot be said to have been obtained from the creditors who have been impacted by the inclusion of this provision in the reconsolidation plan. Hence, such third-party release provisions cannot be said to have been consented to. Next, contrary to what junior counsel for the petitioner argued earlier, that such third-party releases can be granted under Section 1521, we disagree. As earlier espoused by them, in recognizing the discretionary relief under Section 1521, this requires the application of a balancing test under Section 1522A of the New Zealand Bankruptcy Code, where the interest of the creditors must be sufficiently protected. And following the holding in the 2005 US Court of Appeal case of In Re Metro Media, it will be equitable to provide good and sufficient consideration during this process for non-debtor releases. Here, the consideration in question would be the US $15 million cash injection that was promised by Rover Capital, which can be seen at paragraph 21B in the facts. And it's our submission here that this is not good and sufficient as first, the mere US $15 million cash injection pales in comparison to the total debt of US $143.3 million. Second, this $15 million cash injection may not even be provided since Rover Capital, as can be seen at paragraph 35 of the facts, has filed for Chapter 11 proceedings. This certainly raises doubts as to whether they have the ability to provide for debtor in possession financing. Here, since the interests of creditors need to be considered in a whole, especially in imminent liquidation scenarios, it is clear that the creditors' interests here have been prejudiced, and such third-party release provisions are indeed self-serving, since at paragraph 14 of the facts, Rover Capital occupies majority shareholding as well in Fairland Aviation and Fairland Local. Next, regarding junior counsel for the petitioner's point earlier regarding how such third-party releases can be granted under Section 1507, we do agree that what Section 1507 governs the principle that a foreign remedy would only be recognized and granted if the recognizing court has granted it domestically. And here, it's our submission as since the present proceedings are to be decided in New Zealand today, the US domestic law will still be applicable in deciding whether to grant such third-party release provisions or not. Hence, contrary to what junior counsel for petitioner argued earlier, the holding in the 2024 United States Supreme Court judgment of Purdue Pharma would still be relevant and must be emphasized. And considering how we have argued earlier that such third-party releases have not been consented to, these third-party releases would be deemed to be non-consensual, and hence the case of Purdue Pharma would be applicable. In that case, the court held that the bankruptcy code will no longer authorize non-consensual third-party releases, and this paves the way in striking down previous cases that have been employing such non-debtor releases to facilitate fair and equitable recovery for victims. Such definitely holds valid policy considerations, as the main crux will be to ensure that the creditor's interests have been protected, as well as to prevent non-consensual third-party releases from acting as an instrument for wealthy individuals and corporations to misuse the bankruptcy system and win immunity from the claims of their victims without placing their assets on the table for distribution.
But Counselor, like two quick questions. So one is, you mentioned that Purdue Pharma, the case in the United States, is relevant to this situation. So do you think that we should be bound by foreign cases such as Purdue Pharma from the United States? And secondly, you mentioned that sometimes can be detrimental for the creditors, the approval of these third-party releases. But actually, the truth is that in many cases, receiving something as part of our organization plan can be better than allowing the creditors just to litigate and to engage in a very costly, lengthy process that maybe might not ultimately end up, recovering certain assets. So that's why, do you think that maybe getting something in this case would be better for the creditors?
Yes, relating to your first question, it's our submission that the case of Purdue Pharma would still be bounded by this court today, although we recognize that Purdue Pharma's decision centered mainly on Chapter 11 protection. However, it must be noted that since the court was silent there regarding applying its holding in Chapter 15, it cannot be the case that this court today should be hesitant in adopting its decision today in the Chapter 15 context. Second, relating to the second question regarding the US $15 million cash injection, it's our submission that this US $15 million cash injection cannot be said to be good and sufficient, especially since we do not know whether Rover Capital has the definite ability to provide such cash injection, since at paragraph 35, they have also filed for Chapter 11 proceedings. And moreover, it's our submission that alternatives could be better, for example, liquidation, due to this factual scenario here and factual uncertainty presented in this case. And furthermore, Your Honor, I would like to highlight the holding in Purdue Pharma regarding its definition of debtors. And the court held that one can only be considered to be a debtor and be able to discharge their debts if they are the ones that filed for bankruptcy and have placed virtually all of their assets on the table for distribution to the creditors. However, in our case here, it cannot be said that Grant Fairland, Gem Fairland, and Rover Capital would be deemed to be considered under the definition of debtors because they are not the ones that have filed for the present foreign proceedings and also have not filed for bankruptcy. Second, they are also not part of the restructuring plan reorganization plan in restructuring the Fairland companies. Hence, such releases here cannot be said to be integral to this reconsolidation plan, but rather entirely self-serving. Furthermore, in relation to junior counsel for the petitioner's point earlier that just treatment has been satisfied, we disagree, as it is clear that procedural unfairness exists here. Nothing on the facts explicitly gave any evidence of substantive due process or procedural steps taken in ensuring that creditors' voices have been heard. And following the holding in the 2021 US Second Circuit case of In re PT Bakri, the court held that a clear and formal record must be demonstrated to prove that procedural fairness has been taken into account. However, this is clearly absent in our case. Referring to paragraph 21 of the 22 of the facts, your apologies, the reorganization was done independently by the management and the board of directors of the Fairland companies, such that it wasn't clear at all whether the creditors have been consulted or at least allowed to opt out of such third-party releases. Without any due consideration as to the rights of the creditors, granting these non-consensual third-party releases would certainly prejudice the creditors' reach of their legitimate contractual expectation in enforcing the Fairland brothers' personal guarantees. Hence, given that the petitioners here have not provided any specific or given any evidence of how substantive due process and procedural steps have been taken, it's our submission that they have not satisfied their burden to prove that no procedural unfairness exists here. Therefore, it's our case here that the present third-party releases have not been consented to, and hence they cannot be provided under Section 1521 and Section 1507 of the Bankruptcy Code today. Hence, this court should not grant and empower such releases. Unless I may be of further assistance.
No.
This concludes my submissions. Thank you.
Thank you.
Your Honor, if I may begin my rebuttals.
Please. Yeah.
Your Honor, my first point in rebuttal, in response to your questions on forum shopping and the absence of a shift in directors' duties in the zone of insolvency in US law, the respondent argued against the consolidation on the grounds that it was procured in a procedurally unfair manner and that that it has little chance of success. However, this is a bid that the respondent has made and must now lie in. They raised an appeal in a jurisdiction which they now claim is procedurally unfair, a jurisdiction which has also claimed exclusive jurisdiction over the insolvency proceedings. Now they argue that there is a better plan for the purposes of restructuring, a plan which was not surfaced throughout the course of the utopian court proceedings and sprung onto us on the last minute. We say that the respondent's motives must be questioned and that they are simply seeking to treat this court as a domestic appellate court, which not only drains whatever limited resources the Fairland companies have, but is also something which this court should not condone, as seen in its 2012 decision of Cozumel Caribe. Further, junior counsel for the respondent argues that creditors' interests must be visible on the agreement document in order to qualify as consideration. However, this neglects the other considerations that creditors may weigh before granting consent to the releases. One of this is one in which Your Honor noted that the creditors may choose to receive something, then risk litigation and receive nothing. Another consideration is the prospect of successful restructuring. With the Fairland company successful restructuring, the creditors can maintain good business relations and save them the troubles of re-establishing fresh relations with new trade suppliers. Unless I may be of further assistance to this court, this concludes petitioner's case.
Okay, that's all for the round. In light of the limited time, you want to go straight to feedback?
Yeah, sure. So, well, again, as I started, I would like to congratulate you all because I'm aware that this is not easy, so it's always very challenging. And also, I don't know if you guys have taken insolvency law, but yeah, so then that makes this issue even more challenging. But I have to say that even though you guys haven't taken insolvency, it seems that you guys are experts on insolvency, so that's a very good sign. In terms of actual feedback, so for the petitioners, like a few kind of comments. So one is, I understand why you guys cited Garuda and why you guys, wanted to emphasize that, but you need to bear in mind that the way Singapore has adopted the model law differs with the way the United States and other jurisdictions have adopted a model law, and the word manifestly, was omitted in Singapore, while it was adopted in most jurisdictions following the actual text of the model law. And in fact, Garuda is a very interesting example, because actually Justice Sonchi was kind of delivering the opinion of the court, was kind of, trying to come up with many innovative ideas to justify why, even though Singapore omitted the word manifestly, why we should still interpret it, the model law as it was originally drafted, including the word manifestly. So that's why the situation right now is quite even unclear in Singapore, because we have a judgment from the High Court initially saying that the fact that we omitted the word manifestly means something, because that was something that was done on purpose by the legislature. But then we have the SICC say no, even if we have omitted the word, we should interpret the model law as adopted in Singapore as if we would have adopted the word manifestly. So this is kind of one point that maybe I think it was Ryan that was kind of mentioning. So it's important to keep that aspect in mind. Secondly, I think it's important to keep in mind that substantive consolidation is a very exceptional remedy. So some countries have some provisions for substantive consolidations. Other jurisdictions don't have provisions on that. So, for example, the United States is a country where substantive consolidation is not regulated. So it's based on case law and equitable kind of doctrines. And the cases are generally limited to two types of cases. When the company, prior to the commencement of the bankruptcy proceeding, was kind of lying about the real, situation of the company and the different legal entities involved. And the second is like an ex post argument, like after the commencement of the proceeding, it is much easier because it's very difficult to identify the assets and liabilities of each entity, and that's why sometimes it makes things easier just to consolidate everything, and also it's beneficial for the creditors as a whole. So that's why if you guys want the court to recognize the consolidation order, I think it's important to try to emphasize very clearly all the factors that need to be met in order to recognize this, because otherwise countries are going to be reluctant. And even if a country has adopted the model law on enterprise group insolvency, as it is the case here, then that doesn't mean that a consolidation order is going to be recognized, because the model law on enterprise group insolvency kind of embraces a group solution, but that group solution doesn't mean that substantive consolidation will be recognized. So that was one aspect. Another one was the third-party releases. So again, the third-party releases is a very controversial topic nowadays, particularly after Purdue Pharma. Countries around the world have adopted very different approaches to third-party releases. So that's why, again, if you guys want to recognize these releases, you need to show very clearly. First of all, it's important to distinguish consensual from non-consensual third-party releases. So you guys wanted to recognize the third-party releases as consensual, but actually Purdue Pharma was challenged initially in the bankruptcy court of the Southern District of New York, even if the plan was approved by, if I'm not wrong, like 90-something% of the creditors. Not even 75, and you guys have mentioned 70-something of creditors plus stakeholders. So, well, the stakeholders, as I think the respondents emphasize, are not that relevant, the stakeholders. So we need to look at like the creditors mainly. But even within the creditors, in the case of Purdue Pharma, 90-something% of the creditors approved that. and the judge still said, well, this is a non-consensual. Non-consensual can be approved in certain scenarios, or at least before the US Supreme Court decided that in the United States. But you need to show certain elements. So maybe it would be useful for you guys, particularly for the petitioners, to consider those additional elements that need to be considered for allowing these third-party releases. And even if you conclude that certain countries allow that, you need to bear in mind that other countries don't. So that's why it's also important to maybe take a look more holistically to third-party releases to determine what are the releases that we're talking about. Are we talking about just guarantees from parent companies, subsidiaries, or something like that? Or by third-party releases, we're also including like the possibility of suing the directors for misbehavior in the future, like criminal proceedings, because one of the problems with the Sacklers in the United States is that they wanted to avoid any type of litigation against the Sacklers. So that is different and probably more controversial than third-party releases just involving like the discharge of guarantees or something like that with some entities within the group. So that's why, again, I think it's important to keep that aspect in mind. Then another aspect is that, let me see, because it took some notes. Okay, so then recognition, as I mentioned briefly, of proceedings is different from recognition of insolvency-related judgments. So there are certain aspects that you guys need to bear in mind. So one is, again, even if a country has not adopted the model law on insolvency-related judgments, they can still recognize those insolvency-related judgments. But again, you guys need to prove and show how and why. So what are the aspects that can be recognized, in which circumstances, and then also keeping in mind the public policy exception that applies to those cases as well. The public policy exception is very relevant in this case, actually, for two main aspects. One is substantive consolidation. That is by itself a very controversial aspect, not allowed in many countries because that might interfere with the doctrine on like the separate legal entity of each company. And secondly, it's very controversial, the public policy issue for the third-party releases that, again, are countries that don't recognize that at all. If I'm not wrong, for example, France is one of the countries that say, well, third-party releases are not allowed at all. So that doesn't seem to be the case here, but just to, it's important to keep in mind that some countries don't allow that. And then let me see, final aspect that I had was on the procedure. Yes. So, well, the procedural fairness is something that you guys have emphasized as well, and the protection of creditors. So when it comes to the protection of creditors, the concept of adequate protection maybe should be analyzed more carefully, and how it has been interpreted in the context of recognition, because the concept of adequate protection, for example, in the US bankruptcy code means something, but when it comes to recognition and cross-border insolvency, adequate protection means something different, typically more aligned with what you guys mentioned about being heard, like procedural fairness, all of these aspects. But the idea of being adequately protected, I think, is relevant. And in order to prove your point on adequate protection, I think that something also relevant is to emphasize the treatment of creditors under different scenarios. So I think it was, I'm not sure it was Stephanie, I think the one who mentioned that in liquidation, maybe the creditors were going to be better off. So maybe if that is the case, then that's something that the petitioners would want to emphasize. You guys would need to emphasize that the creditors can indeed be better off by recognizing the plan. So that's why I asked the question about showing some comparisons and some kind of indicators on alternative scenarios, sometimes that can be helpful. But yeah, so these are kind of some comments. So I'm aware that some of these aspects are kind of quite controversial. Also, they are relatively new in the Ian Fletcher mode. So I've been a judge in the Ian Fletcher for several years, and of course, the idea of including the third-party releases this year is because of the U.S. Supreme Court, had this controversial decision last year. So maybe particularly for those of you seeking the recognition of the third-party release, you guys may want to take a look at the dissenting opinion of the U.S. Supreme Court, because the U.S. Supreme Court included a dissenting opinion that maybe can provide you with some additional elements to support the idea that the third-party releases should be recognized. So maybe just as a kind of piece of advice. And then for the substantive consolidation doctrine, also, I think it's important to take a look at the case law very carefully to determine when this substantive consolidation can be justified. But in general, I think that you guys have done a great job. So it could be hard to decide, in this case, what to do based on the arguments that you guys have presented to the court. So I probably would say that I've been a bit more convinced by the arguments submitted by the respondents in this case, but also because, again, substantive consolidation, I think it's a very controversial issue. Third-party releases can be a bit controversial, but working on those aspects and the way you guys justify that, I think it would be very challenging for the court to ultimately decide.
Prof, actually, I have a few questions for you.
Yes, please.
Actually, I note that there is a difference between the definition of consensual third-party releases and non-consensual third-party releases. So, by argument earlier regarding the 75% approval, it is only relating to the consensual third-party releases part, right? So, how do I actually prove that these third-party releases here are considered to be non-consensual third-party releases? Because non-consensual third-party releases, if I were to understand correctly, actually favors the petitioners.
Yes, so that's an excellent point. And actually, again, Purdue Pharma is an interesting case. Purdue Pharma was consensual or non-consensual. So it's non-consensual, even though it was approved by the overwhelming majority of creditors. So some of the points discussed here is that you guys have said, the petitioners, that it is consensual because it was approved by the majority of the creditors. But yeah, so depending on how you interpret consensual or non-consensual, the general understanding is that even if it is approved by the majority of the creditors, it's still non-consensual because some creditors were entitled, for example, in Purdue Pharma, to sue the Sacklers, but they were just, prevented from doing so if the judge approves this type of releases. So that's why non-consensual in the case of Purdue Pharma, and that was a controversial thing. So how can you prove that? So to your question, so I mean, you guys can try to convince the court, because again, maybe something good and bad about third-party releases is that many countries have not had a huge debate on third-party releases. So that's why they might not know how they're going to be interpreted in the future. So that's why maybe you guys can try, as actually the petitioners did, to say that this is consensual. Probably the judge is going to say, no, this is not consensual. So then your next move should be, okay, if it's not consensual, can it still be allowed? And the arguments can be, well, first, look at how the US courts have allowed non-consensual third-party releases. There was a case law on non-consensual third-party releases and very limited cases in which they can be approved. So it would be good if you guys can take a look at that, because that can provide you with some guidance. Secondly,
Wait.
yeah, please go ahead. Yeah.
Oh, Regarding your case law, would it be more about the different factors under Section 1123B6, for example, having indemnity relationship, overwhelming acceptance by the impacted class, etc., etc.? Are you referring to
Exactly.
those
So those are
factors?
the formal factors required for the approval of the non-consensual, but still judges have developed those factors, how to interpret those factors. So maybe you guys may want to take a look at that. But even if you prove those factors by themselves, I think that would prove your point that even if it's non-consensual, if you meet those factors, that's an indicator that maybe they should be approved.
Oh, because my concern is that the petitioners will argue that, but would it be okay for the respondents to rebut it by saying that our present proceedings are in Chapter 15 context and not really Chapter 11, so these factors are not applicable?
Okay, so it's a different context, like Chapter 11 versus Chapter 15, but still, if I were the petitioners, then I would say, well, even if we're in a different scenario, those factors are still, because those factors are specified in the United States for the purpose of determining whether it is kind of fair or reasonable to approve the non-consensual third-party releases. That's why they have this list of factors. So that's why in this case, they can mention that those factors, even if they are mentioned in a different context, kind of proof that is reasonable and fair, procedural fairness, creditors are kind of adequately protected. So I get your point. It's a different context, but still, I think they should be mentioned as a way to prove the point that it's kind of fair, reasonable to approve it.
Okay, so for the respondent's side regarding the 75% approval argument, so like you're suggesting to have kind of like a two layer. So first, I will argue against consensual third-party releases, and then I will argue that even though with this Section 11 factors, there hasn't been any overwhelming approval by many of the creditors, so it cannot be said that our third-party releases that we're talking about is considered to be non-consensual. Then I apply the Purdue Pharma.
Exactly. And even a third layer as well. You can say, well, but even if the overwhelming majority, so that can be like the second argument, even if the overwhelming majority has approved this, and that's why there are exceptional reasons for recognizing this third-party release, there are other factors that need to be considered. Because in Purdue Pharma, that was exactly the case. The overwhelming majority approved that, and the US Supreme Court still said no. So this is not allowed. Why? Well, because then you might be affecting the rights of third parties to sue. In this case was the Sacklers, and to try to to get paid, and to so that's why that might affect like the legal rights of kind of third parties that haven't specifically approved that. So that's why maybe your third kind of a layer of argument can be that. So even if the overwhelming majority approve this, you can still say that some parties didn't approve it. So that's why maybe for your point, you should take a look at the, the US Supreme Court, the specific argument. Also, something that was relevant in the case of the United States was the literal interpretation of the law and the powers of the bankruptcy court. So that's why, in the US, in the context of asbestos, third-party, kind of non-consensual third-party releases were specifically kind of permitted, but the law didn't say anything about other type of non-consensual third-party releases. So maybe something that you guys may want to use, depending on who you are representing, is this silence of the law should be interpreted in a positive manner, that the judge can decide whatever is not prohibited, or the judge can decide only whatever it is specifically stated in the law, or at least when it comes to bankruptcy matters, and the judge cannot decide other issues. But it would be good to take a look for both groups, the US decision in Purdue Pharma again, because even if you are in favor of third-party releases, the dissenting opinion I think can provide you with some additional elements. Yeah.
Okay, and can I also check, can the petitioners argue that non-consensual third-party releases are permissible through deemed consent under like cram down measures, etc.? Like how would the respondent be able to respond to this?
Okay, so if they were able to say, okay, I mean, but it depends on how you interpret like consensual, non-consensual. If you interpret that this is non-consensual, so then they can say, okay, it's not consensual. Can we cram down the plan? But
Yeah.
again, the judge would probably say, well, I mean, cram down might not be relevant here because we are considering like a separate thing, which is, well, first of all, the cram down typically takes place in the jurisdiction where you initiate the proceeding. So it's not like in the context of recognition. So it's more in the context of, let's say, Chapter 11, but not in Chapter 15. So that's why the judge will unlikely accept that argument. But imagine that the plan was crammed down in the context of the original reorganization proceeding. And then what you want to do is just to recognize that proceeding, including the cram down in a foreign jurisdiction. But then the question is, can the judge impose a plan on dissenting classes of creditors in the context of third-party releases and not in the context of kind of obligations from the debtor? Because you need to bear in mind that when it comes to third-party releases, is obligations from someone else. So that's why probably that plan will unlikely be crammed down. And then in this context, it's in the context of recognition, not even in the context of the cram down. So that's why I think it's going to be very unlikely that the judge will admit that.
Okay, would you recommend like any case law or like sources to look into for this?
I mean, for cram down, so you have so many cases in the United States. Unfortunately, we don't have in Singapore because our cram down provisions haven't been interpreted yet. But for cram down, you may want to take a look at the UK. The UK has had like 2, 3, 4 cases at least of cram down already in the context of the restructuring plan. And the US has also many cases on cram down. I'm not aware of any case specifically including like the imposition of a plan with third-party releases. So cram down with third-party releases. So I cannot think about any kind of particular case, but definitely it would be good to take a look at the case law on cram down and to whether the judge has allowed like the third-party releases in the context of a plan that has been crammed down. But again, even if that is the case, when it comes to recognition, is actually more controversial because, first of all, not many countries have adopted cram down provisions. So that's why you can say that under your own laws, the cross-class cram down, for example, is not even allowed. So that would violate the public policy of your country. So that's why you can respond by saying that it's an additional argument to reject the recognition on the basis of the violation. So unless the case specifically tells you that your country has adopted a cross-class cram down, that probably is going to be a violation. And again, only the UK, European countries, Singapore, US, and a few others, not many, have adopted the cross-class cram down. So that's why even if the petitioners mention that, you can always say, well, that violates, again, a public policy because we haven't adopted maybe the cram down.
Okay.
Okay, so thank you, everyone. And again, congratulations because, sometimes I know that when you guys prepare this, you take a look at like previous years, like cases, etc. You talk to your seniors, but I'm aware that this year is probably more challenging than others because every year INSOL and III, they try to introduce some new elements. And the ones that have been introduced this year, the consolidation part plus the third-party releases are kind of very innovative in a way, but challenging, not only because they are new, but also because they are very controversial internationally. Countries deal differently with third-party releases. Countries deal differently with consolidation. So that makes the case sometimes more challenging, but at the same time, sometimes it is better because if you don't have like a clear precedent, then you guys have more arguments potentially used like in favor or against. So that's the perfect thing that you should do in the context of a mood like this one. Okay, but again, congratulations to everyone for the amazing work that you guys have done. So I wish you the best of luck. And regardless of what happens, you guys have already won by being part of this amazing exercise. Okay, thank you, everyone.
Thank you.
Oh, Prof, one more thing.
You go, Ray.
Sorry,
No,
unfortunately, you need to go. Yeah, sorry.
sorry, it's just that if you have further questions, can we email you?
What, sorry?
If we have further
I
questions,
mean,
is it
if it's
okay?
okay, perfect. Okay, thank you so much. Thank you, guys.
So sorry, thank you.